Hi guys, welcome back to Nairobi Legal Insights. My name is Rogers Githinji, and in today's video, I'm going to be explaining the nature and objective of corporate rescue, which is one of the key topics under insolvency law and reorganization. By the end of this video, you should be in a position to understand what corporate rescue means and how it is done. And as a law student, if you are presented with a set of facts regarding insolvency and reorganization, you should be able to assess whether a company is undergoing financial distress and what right interventions can be put in place to ensure that a company that is undergoing financial distress bounces back. One of the key things that you're going to appreciate in the course of this video are the formal interventions or informal interventions that one can implement to ensure that a company in financial distress bounces back. Now, when we say that a company is in financial distress, what this actually means is that there is a temporary lack of liquidity. Simply put, the company lacks some cash flow, some money to run its normal operations smoothly. For example, that company could be in a situation where it is breaking promises that have been made to creditors. And when we talk about creditors, these could be people that have, of course, the company has borrowed money from other people. And when it comes to repayments, these promises of payment on certain dates are being broken. Or even in cases where company A is able to honor some of these commitments, it is doing so with a lot of difficulty. Even though if we are to look at company A, it is likely to continue operating for a foreseeable future, but the current circumstances show that there are difficulties in actually honoring most of its commitments. So how do we come in to ensure that this company can bounce back, and what are the right interventions to propose? Can they be formal interventions? Can we do the informal interventions, and to what extent? And if we talk about these interventions, what are they? That is what you're going to be able to appreciate in the course of this video. When it comes to corporate rescue, one of the major key considerations I want you to have at the back of your mind is that sometimes, even if a company is in financial distress, it doesn't mean that we're just going to go and close it down. A company can be in a position of financial distress but remain viable, provided the required interventions are implemented. This company can still bounce back and continue operating at a profit. So for example, if we have company A that is incorporated, companies also have their life cycles, they have ups and downs. So company A at some point can face what we call financial distress. And like I stated earlier, when we say a company is facing financial distress, what this simply means is that the company is breaking some of its promises to creditors, or in the event that the company is honoring some of these promises, it is doing so with a lot of difficulty, even though it can continue operating for a foreseeable future. Simply put, we have a company that is facing a temporary liquidity problem. And when we talk about liquidity, this is money. There is not enough money to facilitate smooth running of that specific company. So that is what we call financial distress. So simply because a company is undergoing financial distress, it doesn't mean that you completely close it down. It can be viable, provided certain interventions are implemented to allow it to bounce back. Now, this brings us to rescue. Rescue is a major intervention that, of course, once implemented very well, it can stop a company from complete failure. And of course, when it comes to implementation of a rescue, it may result into a company being reorganized. For example, if it is company A, we can look at its management and think about what reforms can be implemented within the management of that company to ensure that it bounces back. Do we bring in more competent people? What do we do? Looking into the strength of the leaders and the management and what reforms can be done, within that management of that company to ensure that there is better operations, that can again result into resolving what we call temporary liquidity problems. Then, of course, rescue can also result into what we call restructuring. So a company can be restructured as a result of being rescued. As you rescue it, you could decide to restructure. What does restructuring mean? If we have a chain of supermarkets, we can start closing off certain branches, or certain departments of a particular company can be closed so that we avoid the issue of straining the limited resources. Then again, the other key thing that rescue may result into is what we call refinancing. To rescue a company, you can decide to inject in more capital in the company. If we have company A facing financial difficulties, is in financial distress, we can inject in more capital. And then, of course, if company A has many creditors, what can be done? You can think about renegotiating with these creditors so that these debts are rescheduled. So, for example, you can negotiate on the terms of payment. How do you extend the terms of payment? You can ask for more time from creditors so that you balance out the duration of payment. That way, you give the company some time to work through its challenges. So refinancing, injecting in more capital, can be one of the ways of actually rescuing a company. The other way in which rescue can again be implemented is through downsizing. You can also downsize. If we have a chain of supermarkets under one parent company, we can decide to reduce on the workforce, cutting down on non-essential activities to allow again save on costs and preserve the limited cash that is within that specific company, so that again the little resources in form of money that are available at the moment are used for the most critical activities of that company. Again, to rescue a company, you may think of sell-offs. You've had situations where parts of a business have been sold off or taken over by other companies. You know, a company could be facing challenges and then you decide to sell off certain parts of the business of that company. So in a nutshell, when we talk about rescue, it can result into a company being reorganized, restructured, refinanced, downsized, and sell-offs. And remember, as you implement each of these things, you're rescuing the company, which is in a position of financial distress, so that these actions can reduce pressure on that company to resolve its temporary liquidity problems and continue to bounce back over time, hoping that then it can make profits. So that is indeed how rescue works. You're rescuing this company that is facing financial distress by implementing certain key actions so that then it bounces back. So that is one way of ensuring that the company does not completely fail, because there is some viability in that company, but simply because certain interventions were needed to ensure that this viable company continues to operate. Taking a moment to reflect on what I just shared, those examples would fall under informal rescue interventions. Basically, any typical business person or directors of a company or even management would think of those actions in order to allow a company that is facing financial distress to bounce back. So for example, one would think of restructuring, changes in management to bring in more competent managers. And then of course, someone would think of downsizing, sell-offs, really to ensure that with the limited resources, the company continues to operate and overcome its challenges. On the other side, when we talk about formal rescue procedures, these are within the context of the Insolvency Act of Kenya. Once we invoke them, then we have legal procedures coming into play. And some of these insolvency procedures in Kenya include administration and liquidation. So for example, if a company is facing serious financial difficulties, an administrator can be appointed. And once the administrator steps in, he will come in to manage the reorganization of that company so that it can bounce back out of the situation of financial distress. Remember, there is a clear distinction between administration and liquidation. With administration as one of the insolvency procedures, it really allows a company to continue operating because this company has its viability. The administrator is coming in to ensure that things are fixed and the company can continue operating simply because a company is facing financial distress, it doesn't mean that you have to close it down. But in the event that the administration process is completed and there are still major problems as far as that particular company is concerned, then that company will move into liquidation. And once a company moves into liquidation, that is the deathbed of a company. It has to be closed down. And of course, formal rescue interventions have their own advantages. So for example, there is a benefit of what we call a moratorium. This is breathing space given to a company to allow it to reorganize its affairs. So during the period of moratorium, if company A, for example, had 1,000 creditors, it has to pay 1,000 people. And these 1,000 people are aware that company A is facing financial difficulties. All of them will be rushing to ask for their money. And for them to get their money, they may start instituting individual legal suits. Now, what that does to a company that is already facing money problems is that it is going to spend more time defending itself in court and even using up the limited resources left. So with administration in place, the advantage is that once that moratorium is in play, it acts as a freezing order where creditors can no longer drag the company to court. Of course, if a company is continuously dragged to court by various creditors and it's in a situation of financial distress, that is going to derail the process of restructuring. So that moratorium, which is a breathing space, acts as a freezing order where no one can no longer sue the company so that the administrator is given sufficient time to reorganize this company so that it can bounce back and then start paying off its creditors and even make profits in the long run. So that is the advantage of administration. So when can you propose administration as one of the insolvency procedures? This particular concept is covered in one of the previous videos I made. And then, of course, once a company moves into liquidation, what does that mean? What are the implications of liquidation? Again, that was introduced in some of the videos that you can access under the playlist on Nairobi Legal. Of course, once you click on the playlist, you will find a section on insolvency and reorganization in the Kenyan context. So those are the benefits of formal rescue interventions. And then, of course, on the other side, you can also see the benefits of the informal rescue interventions. So you can read through a certain problem question and see the most appropriate interventions, because you can't skip the basic informal procedures such as maybe restructuring, change in management to quickly jump into the formal ones. So when you read a situation, how can you pick out the best approach to tackling the question and proposing the best alternatives based on the context that you've been presented with, based on the context of a company or a situation of a company that you've been presented with. Having introduced both the formal and informal corporate rescue interventions, the next key question you may have is that how do insolvency proceedings begin and what activates them? That will be the purpose of our next video. But to better understand administration as a rescue mechanism, please go on the Nairobi Legal Insights YouTube page, click on playlist. You will find a playlist on insolvency and reorganization, and there will be a video which is one of the older videos explaining how administration works as a rescue mechanism. Thank you for watching this video. Our goal is making the law simple and clear. Feel free to follow us on our LinkedIn page and TikTok, Nairobi Legal Insights. My name is Rogers Gidinji, and see you next time.